I'm really excited about, this panel, this presentation. I think nothing could be more timely. But I also think that one of the important things that we all have to do is understand branding, understand how to brand ourselves, how to brand our program, how to use everything that you have to build your brand, because that's an important piece of this. And so we're really lucky today to have a couple people who are going to really lead us through this. And first of all, I'm going to introduce Kevin Barefoot, who is the Director of Business Development at the Collegiate Group for Teamworks and INFLCR. And of course, Teamworks and INFLCR have become, sponsors and partners with us. So we really appreciate all they do. And then a little bit later on, Kevin is going to introduce Darren Heitner, who is, I guess, the founder of Heitner Legal, and he has been very instrumental in developing NIL concepts, legislation. I know he's been very involved with the state of Florida from the standpoint of developing, NIL legislation, but I'm sure he's on top of what has happened and where things need to go. So what I'd like to do now is turn this over to Kevin Barefoot. Great seeing you again. Kevin and I go back a ways and always enjoy hanging out with him. So Kevin, you're on, man.
Yeah, thank you, Doc. Hello, everyone. Good afternoon. It's great to see everyone. Wanted to start by saying, thank you for having us in. We're excited about the opportunity to partner with TopConnect. I've long known about and respected the organization that, formerly Bill 7, now TopConnect, but the job that you all have done both for coaches and administrators and advancing careers. And so just a ton of respect for this group. And so we really jumped at the opportunity to take part in this deal and have the opportunity to sponsor. So we appreciate that, particularly, Doc Sanders, Mark Benson, Wood Seelig, Cheryl, the entire group at TopConnect. We're appreciative of this opportunity. So I see tons of familiar names and faces. Hopefully we can do this in person in the relative near future. We'll be partnering up with TopConnect obviously today, but also for future events. And so I look forward to when we can actually shake hands like normal human beings again. But we got a two-part session today. Part one, as Doc mentioned, we're going to talk about branding, but we're also going to just dive into, the things that you and your department can be doing right now and in the coming months to succeed in the NIL era, right? So this isn't me going to be pitching you on influencer. What we're trying to do in the first part of this session is really just share with you the insights and the best practices that we're seeing across the landscape, because we're interacting with schools every single day as it relates to NIL preparation and brand building and topics like that. And then part two, we're going to open it up for an interactive Q&A. So we're going to bring in Darren Heitner. Darren, I'm sure, is a name that you all recognize. He is the founder of Heitner Legal, is one of the preeminent sports law attorneys in America. And so anytime there's breaking NIL news, you see Darren quoted in Sports Illustrated and Forbes and CBS, because he's a great source of information. So we're fortunate to have him. And so if you have questions about the NCAA waiver that appears to be coming down the pipe, or Alston, or any of those topics, write those down. And in the second half of this, we're going to get to Darren and do a Q&A, and would love to hear some of your questions. So let's get started and just talk about, what we're seeing in the market and some ideas and themes and concepts that you all can take back to your campuses. And the way that, my brain works is that acronyms help me remember things. And so we want to talk about some NIL best practices, and BEST stands for building student athlete brands, educating student athletes, showcasing your institutional brand effect, and also really just taking a transparent and proactive approach in the coming days, weeks, and months. And before we go through each of these items, and we're going to start with student athlete brand building, I want to start with the why. Why should you all as administrators and institutions care about and want to help build the brands of your student athletes? And it's not just to appease 18 to 22-year-olds who want to post pictures on Instagram and Twitter, right? There's a deeper reason behind it. So let's talk about that. The simplest way to say it is that your student athletes are your best marketers. A study by #Sports last year revealed that 68% of your brand audience is reached through non-owned social media accounts. Non-owned are accounts that are your players, right? So on average, of the people that follow your program socially, they do it by following your players. People follow people. And in addition to that, if you dive deeper on who follows student athletes, 75% of their followers are fans, donors, and recruits, right? It's the exact audience that you want to reach. And if we look at specific examples, and I'll share this, Nevada, I'm sure Doug wouldn't mind me sharing this. They're actually coming on board with us this week. And, I showed him this graphic, but this is a graphic of Nevada's football Instagram account, right? Team following 15,000, pretty darn good, frankly. But if you add up the collective following of their players, nearly 120,000 followers collectively, right? So 7.7 times audience reach. And this isn't anything, for clarity, this isn't anything that Nevada Social is doing wrong, right? You could cherry pick, or you could pick any team and on any campus across the country, and this is what you will find. People follow people. And, another example is Oral Roberts. You can see, between 3 and 4 times X audience reach for Oral Roberts. Now, I love telling this story because, as many of you remember, Oral Roberts had a phenomenal run in the tourney, right? Sweet 16, really made the most out of their 2 weeks in March in the spotlight. And they did what I kind of refer to as the most well-timed trial of influencer in world history, because they implemented influencer the day before Selection Sunday and used it over the next 2 weeks. And, their staff responded. They uploaded 2,300 photos during that 2-week span. Their players and staff shared 649 pieces of content. And they captured these moments that you see on the screen. They captured this moment of momentum to help build student athlete brands. But as I mentioned earlier, it's not just about student athlete brands. Rising tides float all boats. So this is the team following account for Oral Roberts, where they increased their following almost 400% in 13 days. And so if we go back to the original premise, why should you all care about building student athlete brands? It's this, right? There's this massive marketing opportunity that exists for your programs. And that's really what Influencer was founded on. But at the end of the day, this is a marketing opportunity that exists before we even talk about NIL, right? There's just a marketing opportunity that exists by leveraging student athlete followers. Now, as we flip the page and talk about how do you go about building your student athlete brands, the first thing we talk about is just an expansion of content producers. If getting content to your student athletes to enable them to post it to social so they can build their brands, and also help you build your team and department followings. If that's how you go about building brands, is delivering content to them, then it also is logical that you want to expand the number of people on your campus that are actually producing that content, right? That means photographers. But you can do this in a smart way without adding a lot of costs, right? You can leverage graduate assistants, student assistants to capture content. You may want to partner. If you have a journalism school on your campus, right, create some internships there where you can have journalism students who are having access to the football field before and after a game, or community service events and those types of things, so they can capture more content. And when you're capturing that content, obviously you want to distribute it down to your student athletes. But it should be beyond just pictures, right? Short form, long form videos. How can you help student athletes capture the moments that they're making in their careers at your institution? And one of the trends that we're seeing is that some of the most commonly shared content by student athletes is actually not the on-field or on-court content that you normally think about, right? It's them at a children's hospital. It's them taking part in social activism. It's them, hanging out with their friends and teammates before and after a game. So as you think about how do we create more content producers, also think about how we can deploy them, right? Where do we want to put those content producers to grab content that we're going to be able to share with our student athletes? You also want to do it as quickly as you can. If I'm a student athlete and I'm at a community service event or at a game, if I don't get those photos for 2 weeks, that's old news, right? We want to shorten the loop in which you are getting content to student athletes, because that's critical. Timing does matter. There is a direct correlation between how quickly they get content and the event that it was captured at, and if they are willing to or going to post it. And again, we talked about this rising tide floats all boats scenario. We see that across the board, by the way. You know, when we partner with schools and, you know, Influencer kind of automates the process of getting all this content to student athletes. But when we see student athlete brands grow, we always see team accounts grow as well. So there's definitely correlation there. But the other thing you want to do is think about tracking your student athlete's social statistics, right? We want to understand their brand value. When a student athlete shows up on your campus, you capture measurables, right? 40-yard dash, max, bench press, vertical leap. We're capturing typically athletic related information, probably academic information as well. But this is a new category of data that you want to start capturing, because as we'll talk about in a couple of minutes, you need to be able to showcase how you are helping student athletes grow their brand over time and the resources that you are providing to do so, right? And so that starts with just creating a baseline that when a student athlete steps foot on your campus, here's what they look like, here's their following, here are the social media platforms that they're active in. And the reason that you want to do that is in part because it's a great recruiting story. This is a new frontier that we're kind of entering as it relates to recruiting. But at the end of the day, editorial growth or following growth, if I'm a student athlete, directly correlates to my commercial value, right? So this is a graphic showing Devon Dotson, guard at Kansas. He was there a little less than 2 years, and he nearly doubled his following in the 2 years that he was at Kansas. And what that translated into was a significantly higher commercial value for individual paid posts, if he were able to do it back then. Student athletes soon will be able to do that. But you can see the top numbers show what he would be paid for one on average, based on fair market value data, what he would earn for one post on social media. The bottom is if he worked at it consistently, what he could earn from the time he got to Kansas to the time he left in a year period of doing paid sponsorships. So again, brand building is important because a rising tide lifts all boats. There's this great recruiting story to tell, but actually brand building is one of the ways in which your student athletes are going to be able to monetize. And you want to do everything you can to tell those monetization stories for recruiting purposes. And so all of this ties together. The second thing we want to talk about is educating student athletes. And this is a really obvious one, right? Everybody's focused in on how are we going to educate our student athletes. But just to share some basics that we're seeing folks do well, and in some cases maybe not, to reinforce some of these concepts. But the first thing is you want to proactively communicate what resources you have available for student athletes now, and then also when they're coming. So what you don't want is student athletes not understanding what tools they have access to through you and then going out and seeking tools elsewhere, right? That's a recipe that could get you in a sticky situation. So just communicating with student athletes, hey, we have these tools in place. We're going to roll out a new set of functionality and tools by the middle of July. We're going to have these workshops coming up, in mid-August. And so just communicating what resources are available. Financial literacy should really be at the foundation of a lot of what our educational curriculum would look like. Business IQ, right? Basic information to help student athletes understand what's the difference between 1099 income and W-2, right? There are many student athletes out there that don't maybe understand the difference between a checking and a savings account, right? So helping them understand the very basics, and you don't have to wait until July 1. We're right upon it now, right? But you don't have to wait until NIL is active in your state to start doing some of these things. A big one is just identify campus resource sharing opportunities. I think really smart campuses today are partnering with their business school. right? You might have resources that are within walking distance of your football or basketball arena. Go to the business school, right? We talked about the journalism school earlier for content creation, but go to your law school. Film professors giving introduction to personal finance lessons, right? Partner with them to deliver relevant content to help educate student athletes. You have resources available to you today. And so look at opportunities to leverage those. Also lead athletes to water, right? I think about, my 11 and 9-year-old, right? We have to kind of practice how to do things the right way. I got an 11-year-old son, and I'm repetitively talking to him about, like, when you speak to an adult, you need to speak up, you need to look at them in the eye, you need to shake with a firm handshake. Kids don't intuitively understand those things, so I'm trying to teach them. And in the same way, many student athletes may not intuitively understand that, man, if I start putting money into a Roth IRA when I'm 19 years old, what that's going to mean for me when I'm 40 or 50, right? Or dollar cost averaging, the concept of just every month putting a little bit into some of these financial vehicles, giving to charity. And we're going to talk about how to leverage some of these, right? But really, beyond just building the basics, talk to them about where they should go, what they should do with any income that comes from NIL. But regardless of regulatory uncertainty, and we're going to get into that with Darren, I think we actually got a little bit of potential clarity last night. But, what can you talk with your student athletes about right now, right? So again, whether your state has a bill signed or not signed, or it's being reviewed, or any uncertainty associated with NIL that you may be experiencing, there is information that you can share right now, right? You can talk to them about limitations on their Pell Grants, right, for income earned and how that might affect their eligibility. You can talk to international students about what NIL income might mean for their eligibility. So take action now to educate student athletes. We want to talk about showcasing your brand effect. What does that mean? It means that you're helping student athletes, both prospective and current, understand the impact that your institution has, right? And so when you think about showcasing brand effect, think about turning early NIL wins into PR opportunities. So it's no secret that there is a massive hunger in the national media for stories about NIL. And there is going to be, you can only imagine, in the coming months, right? Everybody from a media perspective is going to want to be talking about how student athletes are earning money, what they're doing with it. So if you rewind and think about that last slide where we talked about Roth IRA investment, charity, helping family members, right? You want to document those things with student athletes, and then you want to seed that with your media connections, right? If there's going to be stories written about your institution, make sure that you are communicating the great ones, right? About the education your student athletes are getting, what they're doing with the money, right? And so try to turn those NIL wins into positive PR opportunities. Also think about establishing the impact and measuring the impact that your institution's stage, what you're providing for student athletes, what impact that has on student athletes, right? You have this great broadcast audience, depending on where you are. You have this, maybe really high attendance at all your sporting events. But in the same way that we wanted to create that baseline for student athletes' social media following when they get to campus, you want to use that growth over time to demonstrate the effect that your institution is having on that brand growth, either through the tools that you're providing them or through the stage that they're on, right? So Zion Williamson continues, even a couple years after he's left college sports, he continues to be kind of the poster child for NIL, right? How much money could Zion have made? And so it's a fun story to talk about. But I love Zion for this example in particular, because not only do student athletes that are high profile help the institution helps them, right? And that's what you all should understand too, is you all are providing a lot of value to your student athletes. So when Zion got to campus at Duke, he had 1 million Instagram followers, which at the time was unprecedented, right? As people's, kind of minds were blown that this high school kid had 1 million Instagram followers. He was at Duke 8-9 months. He left with 3.5 million Instagram followers, right? So your stage, the opportunity that you're providing to student athletes is something that you want to showcase, and you want to do it as you think about recruiting as well. And not only do you want to document those growth stories, you want to document the earnings growth potential, right? Want to share that the last point guard that came out of North Carolina with us, right, grew their brand this much. They grew their monetization opportunity this much, and try to display and show that information. And not only recruit based on the brand building, but also recruit based on the education. You know, with those educational resources that we talked about, whether it's influencer or somebody else, that's stories that parents want to hear, right? So that's a great story to tell, not only about brand building, but also about the educational resources that you can provide to student athletes so they can succeed in this era. And then I won't get into too deep into this. I think this is an emerging trend. You know, we saw UNC do it with the Brander group. You know, kudos to Bubba and his team for really thinking progressively about this. But I think there's going to be opportunities for group licensing, potentially for current student athletes in the future, but also certainly today for former student athletes. This is a great way to engage alumni, create monetization opportunities for former student athletes, and then amplify your brand. And then finally, you know, the T of my best acronym is just about taking a transparent and proactive approach. So many of you probably know Chris Kingston. Chris works at Learfield today, but he's the former athletic director at Bowling Green State University, and really funny guy. But he has a military background, and so in his military training, he learned this process called a 0-hour countdown. It is basically conceptually planning for expected events. And then what are you going to do in each moment after that event occurs? Because a lot of times, particularly think about the military, you can't be reactive. If a base gets overrun or an installation comes under fire, you can't be wondering or discussing what to do. You got to know, and then you got to do it. And so when Chris was at Bowling Green, he actually had a 0-hour countdown playbook for, you know, if there was a sexual assault on campus, player gets arrested, X, Y, and Z, right? He had literally several dozen scenarios in which he would map out minute 2, I'm calling my president. Minute 7, I'm calling a senior staff meeting. Minute 14, you know, I'm pulling together my general counsel. Now, you may not have to get down to the minute, but the point is there are things that we know are going to happen, or we can reasonably anticipate are going to happen. So when you think about a proactive approach, you know, what are we going to do when a student athlete monetizes an Instagram post wearing our university mark? All right. So have those mock scenarios with compliance. Have those mock scenarios, identify what those are. Share what you know and what you don't know with student athletes. There's a lot of uncertainty. We're all experiencing it right now. But if you can communicate with your student athletes, listen, these are the things that we know. These are the things that we don't know. Again, it's going to avoid that situation where a student athlete starts to wonder, well, I need information. I got to figure out a way to get it, right? And that source of information is likely not going to be a reliable one, certainly not as reliable as your institution. So be sure to share with your student athletes what you know now and what you don't know. You don't want to back up a dump truck of information to student athletes on July 1 and dump it on them, right? So be proactive in sharing what you know and what you don't know. Also, I think it's smart to establish a communication cadence. At Influencer, we literally every single day at noon, we have an NIL stand-up. That's what we call it. It's a standing meeting. Certain managers come in every single day. What are we worried about today? What are we working on today? Who needs help? Right. So I think I'm seeing campuses, and I think it's particularly smart. Share with student athletes. We're going to be sending out a communication every single Monday with information as we get it. Right. So that is a source of information for you. In addition to that, every Monday and every Thursday, we're going to have from 12 p.m. to 1 p.m. local time. We're going to have an open Zoom session with compliance, legal, and somebody from administration. We're going to answer questions from student athletes. So if you share communication cadence with student athletes, they're more likely to engage and understand where they can find information and also seek that out from you. Communicate some if-then scenarios to student athletes. And again, these are things you can be doing now. You don't have to wait till there's a law passed in your state. Everybody on this call knows what to do if something does not go according to plan on an airplane, right? If the oxygen masks drop, what do? Right? You put your mask on first, and then your neighbor's on after that. So again, there are going to be situations where you want to go ahead and communicate and drill into your student athletes. If you do this, these are going to be the repercussions. While there is uncertainty, particularly in states that don't have legislation today, you can begin to communicate with student athletes about those if-then scenarios. If you do not set aside taxes for money that you earn as a 1099 employee, you're going to be in trouble come next year, right? You have to set it. So those are the types of things, those mock scenarios that you can begin running on your campus to ensure that you're prepared. And then finally, I don't want to tell you all how to run your staff meetings, but this is an exercise that I think I've found useful at Teamworks and INFLCR. But, many of you as senior administrators, aren't necessarily in contact every single day with compliance or legal or communications or, all the folks that are involved, coaches in the NIL planning and preparation. And so at the end of every one of our meetings, when I'm meeting with our teams, we share a worry list. What are the top things you're worried about right now? And what's been helpful for me is you start to identify some trends. You start to identify some commonalities. If I have 2 or 3 people that are saying I'm worried about X, Y, or Z, then I know as a leader that it's incumbent upon me to address that. And so I think it's also a way in which people can kind of feel comfortable just sharing 1 or 2 items. Hey, I'm worried about, maybe some weeks there's nothing. Ideally, that's the case, but it's a great way to hear your staff out and something that I found useful. So I wanted to share as a throw in with you. So that is my time on the first part of this. That's where we'll wrap it up. Obviously, if anyone has questions or would like to dive a little bit deeper into any of these topics related to this acronym or questions about NIL in particular, we'll be happy to have that conversation and even share this content with you after the fact. The next portion that we're going to jump into is talking with Darren Heitner. And, many of you have probably heard his name. Darren is the founder of Heitner Legal. He's, as I mentioned earlier, he's an former adjunct professor at the University or Indiana University. He's contributors to several major news publications, co-founded Collegiate Sports Advisors, who works with universities and campuses, but most recently actually assisted in writing the NIL bill in Florida. So there's nobody that's more plugged into all these issues than Darren. And so we welcome him today.
Thanks for having me, Kevin.
Yeah, welcome. We appreciate you joining us. I joked with Darren yesterday that a lot of us put up fake Zoom backgrounds to look like we're somewhere fun. Darren actually has the real Zoom background of palm trees. So congrats, you've won the Zoom background race early. But no, man, I appreciate you joining us and jumping in. Darren and I were talking a couple of days ago, and I said to Darren, like, man, it would be nice to just not really be speculative in this talk, this Q&A. It'd be nice if we had some kind of guidance as it relates to what is going to happen in the coming weeks. We got a little bit of a gift last night. Assuming that this reporting is accurate, it would appear that the NCAA is poised to provide a waiver to states across the country, which would basically, mean that if you have a state law, you follow it. If you don't, then you can make your own rules. So, Darren, I want to start there. So we assuming that waiver comes to fruition, what does that mean for schools who are in states with legislation today, and then for the schools who do not have existing legislation today? Let's start there.
Sure. And first of all, I wouldn't necessarily classify it as a waiver. I do still think there will be a select few regulations, or what the NCAA has talked about being guardrails attached to whatever the NCAA national policy is. And I do think, number one, there will be a restriction on prospective college athletes being able to benefit from their name, image, and likeness. And number two, on the national level, I think it's going to be made very clear that there can't be payment, or the universities cannot cause payment to be made to the athletes themselves. Outside of that, the expectation is, as Kevin just alluded to, at this point, and I know we're only 7 days away, that between now and then, and in fact, CBS's Dennis Dodd last night said he thinks it's going to be the day before July 1. But at some point in time between now and then, the NCAA will likely tell the schools and the conferences, this is up to you. We are wiping our hands clean of this particular issue. And in fact, just I think an hour ago, interestingly, Justice Wilkin in the Ninth Circuit, who actually was the district court judge in the Alston case, which I'm sure we'll get into, just made a decision on a pending motion to dismiss in a case concerning name, image, and likeness that the NCAA was trying to have outright dismissed, finally made a decision, was probably waiting for the outcome of Alston, and did not dismiss the litigation. And the litigation is actually brought by players on antitrust grounds, similar to Alston. But whereas Alston was about academic related benefits, this is about the NCAA restricting athletes from being able to benefit from their names, images, and likenesses. So if we needed another reason, or if the NCAA needed another reason to be hands off, it was just given another. But Kevin, to your question, what does this mean then, first, for schools in states that have already passed laws? To the extent that those laws will be going into effect as of July 1, and as we sit here today, there are only 6 with absolute certainty will go live July 1. That's Florida, Georgia, Alabama, Mississippi, Texas, and New Mexico. I think I said all 6 there. Oklahoma and Nebraska have laws that must go into effect by July 1, 2023, but can actually turn them on at any point in time. And then there's the expectation that there may be a few others, including Oregon, Illinois, and Ohio being a few of them, with bills that are either at the governor's desk or will be shortly. And so we could see more states passing those laws with effective dates of July 1. In those states, those state laws will control. And that would have even been the case had the NCAA decided, and it still could, but had it decided to debate and pass its own legislation that it's had for many months, that the Division I Council was supposed to look at back in January.
So the net of it, so the net of it, for if you have a state law in place, the states we just mentioned, you need to have your compliance and legal team studying that state law and know it inside and out, because that's really going to be the rule, the law of the land for your particular institution.
That's correct. And to the extent that the state has adopted any additional regulations, be cognizant of that as well. In the state of Florida, there was a regulation that was adopted between June of 2020, when Governor Ron DeSantis signed the legislation into law, and today. And that the only additional aspect that was brought into the equation with that regulation concerns the use of school marks. So in Florida, for instance, athletes will be able to use school marks only if they receive the express consent of the university, which can be withheld. I know that's something that various athletic departments have been looking at in the state of Florida, and in fact, asking questions to me within the past 24 hours about. Outside of those states that have passed legislation with the July 1 effective date, including the remainder of states that have passed NIL laws but have not yet put them into effect as of July 1, it will be up to the universities, again, assuming that this is what the NCAA does, it will be up to the universities to establish their respective policies on this specific issue. And from what I've heard and read, it's most likely going to be that the NCAA will require the universities to publish those policies on their official websites so that the athletes, at least impliedly, have knowledge of what those rules and regulations are.
Got it.
So that's really where we stand today.
Got it. So if you have a state law, study it. You need to know it. If you don't, it really sounds like it's time to start, if you haven't already, developing what your own set of rules and bylaws may be. Darren, do you, I know this is a little bit of a speculative question, but do you expect, like most of us, that there will be a federal bill at some point that will override state legislation and also school level regulations?
Sure. I mean, we've seen many federal proposals at the national level in Congress, none of them that have actually been debated thus far. In fact, you don't even have to look at this current session. You can go back to 2020 when I think 3 different pieces of legislation were drafted. In fact, Marco Rubio from my home state was the first lawmaker to draft any sort of legislation on this subject on the national level. But we've seen so many different proposals since then. My understanding in speaking with many lawmakers, and in fact, I have a conversation at 4 p.m. Eastern today with the U.S. Senator's office. There's still absolutely an intention to do something on the national level. The NCAA has been pushing and prodding for this to occur. What's interesting is this name, image, and likeness issue is completely nonpartisan. And I think the proof of that is in the fact that now 19 states have passed legislation on this subject with relative ease very quickly. The issue on the federal level is that a nonpartisan issue has become very partisan, where Republican lawmakers want certain things added, Democrat lawmakers want other things added. And I think the biggest problem is this is becoming a larger issue than just name, image, and likeness. And I shouldn't say it's a problem from my perspective, but it's just making it more difficult to pass any legislation whatsoever. Obviously, there are other important rights for the athletes, but that's why we've seen a delay. At one point in time, I thought it was more likely than not that there would be federal legislation passed before the end of this calendar year, based on the most recent hearings in the Senate. And that is likely where any legislation will arise from. Based on my observations, I don't think that's likely to happen anymore. If there's going to be legislation passed and signed into law by President Biden, my guess at this point in time is that it would actually bleed into 2022.
Wow. Okay. So in a shocking turn of events, politicians have become partisan and slowed these things down. Got it. Right. Okay. If I'm at a school in a state that does not have legislation and I'm going to be making my rules, are there any suggestions or tips that you might have about how I should operate in the time between July 1 and when any federal legislation comes into play? And any, like at a high level, any thoughts there?
Absolutely. In fact, I woke up at 5:30 a.m. yesterday and jotted down, I think, 8 different bullet points that I think are very important for universities to consider. And I have the perspective of helping draft the legislation in the state of Florida back at the end of 2019 and seeing its changes, and then the states that have since passed legislation. And I think that there are good components of those other pieces of legislation that have been drafted since then. I think first and foremost, it has to be made very clear that athletes can earn compensation from the use of their publicity rights. And that includes their name, image, and likeness, and that they can use these rights to promote their athletically and non-athletically related businesses. So that could mean doing endorsements, signing autograph deals, doing personal appearances, and so on and so forth. But the caveat to that, and I think you need to make this very explicit, is that the compensation cannot be provided in exchange for their athletic performance, nor for their attendance at the university.
What would there's a lot of discussion around this. You can't be provided in exchange. Does that just mean that anyone providing compensation to the student athlete isn't explicitly saying, if you come here and play, I will give you X? Because it seems understood that the reason that a student athlete might be getting paid is simply because they are a marketable student athlete.
Sure, but it can't, for instance, you can't have bonuses tied to performance on the field or on the court, right? So obviously part of the reason why a brand will want to associate with an athlete could be because of how well the athlete does perform on the field or on the court, but specific compensation elements cannot be tied to performance achievements, in essence.
Got it. Okay.
The other thing I would expressly point out, because there has been questions surrounding this, is that any compensation that's earned will not affect grant and aid or eligibility to participate. And that includes cost of attendance, that nothing will be revoked or reduced as a result of participating in name, image, and likeness opportunities, or as a result of working with any professional representation. I think you want to be very clear that professional representation is fine. I think it's right to understand that athletes who are 18 to 21 years old should have reputable people assisting them. Obviously, you don't get involved in any way with regard to the diligence concerning that process of who they decide to have represent them. But as long as the individuals are licensed, properly licensed in the state as an athlete agent, there should not be an issue whatsoever there. I think going back to what I mentioned earlier about Florida being one of the states that talks in its regulation about the use of marks, that's really important too. I think you want to outright say, unless you have our express consent, you can't use our marks. It's an intellectual property issue. You don't want to have a legal issue by and between the university and the athletes. And I think you should try to develop a good policy with regard to how, in what instances you would allow an athlete to use your marks and in what cases you would not, and try to be very consistent in the way that you apply that policy. So this is something that I would take out of every state law that I've seen thus far, which is that if there's an entity that you have that's supporting or benefiting your institution or your athletic programs, et cetera, that entity cannot also compensate or cause compensation to an athlete. You want to avoid those types of conflicts. And I know people have referred to it as the booster rule. It's not technically a booster rule, so I'd be cautious about that. But that's something that you can just copy and paste from pretty much any state law that's been passed thus far on name, image, and likeness.
Yeah, we've seen it in Georgia, South Carolina, Mississippi, Louisiana, and transparently for this group, that's helped define our strategy at Influencer. I mean, if you look at Florida state law and other those states that I just mentioned, it is explicitly clear that if we are partnering with you, the institution, we are not also allowed to be a marketplace. We can't take money from brands and then give it to student athletes. And so part of our services offering and strategy is that we remove ourselves from that. Student athletes can come in and learn about opportunities, but we are not party to any of those transactions because of the clarity of that law. And I think that's probably a commonly misconceived component, Darren, that a school cannot, based on many state laws, partner directly with the marketplace. There's conflicts of interest that lie there.
That's based on every single name, image, and likeness law that I've seen thus far. Absolutely.
Yep. What other tent poles? I kind of think about them as tent poles, but if I'm general counsel, if I'm the folks that are going to be working on these school specific bills, what other kind of tent poles should we have in place as we're putting pen to paper for the first time on developing these rules for our school?
Well, there's an extremely important provision that whether you're in a state that has a law or doesn't, as the university, this is on your shoulders. So you need to create a process for which the athletes will disseminate their deals to you. So there's disclosure requirements in every name, image, and likeness law that I've seen thus far, and most of them leave it up to the universities within the state to establish what that policy will be. So my suggestion, and I've had conversations with various universities thus far, I think to an extent you owe it to your athletes to try to shorten the window as much as possible. A lot of athletes will become very marketable based on what they do, their performance in a given game, and a brand may want to benefit, from what that athlete has done. Again, it's not paying the athlete a bonus for performance, but I think inherently athletes are going to be more marketable within given windows. So, one thing, and at the same time recognizing that you don't want to overload your compliance department.
So to break that down, what you're saying is you as part of this school level law rules, the school has the authority to require disclosure by the student athlete, and then B, potentially setting a time frame or window in which between transaction and reporting there is a requirement. Maybe it's 48 hours or whatever the case may be. Is that correct?
That's right. And what I would suggest is 96 hours. I would suggest 4 days. And you can, I'd be very careful with regard to the acceptance or rejection part of that process. I think by and large, 99% or more of these deals should be accepted, but you obviously want to have the opportunity to review the text within any deal, whether it's a long form contract, a back and forth email that's considered a contract or otherwise. One, if you're, let's say, in a state that has a provision within the law that allows the university to void a deal if the terms of the deal between the player and the brand conflict with the terms between the university and a brand, that there are state laws that allow you to basically void that deal if in fact you wish to do so.
So this would be if you're an
So
Under
that
Armour school. This would be if you're an Under Armour school and a student athlete does an endorsement deal with Nike, you should have the right to void that because it is interfering with an existing contract between the institution and the vendor.
Not necessarily. So most of the laws say that the specific terms of the deal have to be in conflict. And that's a really good question, Kevin, because hopefully schools don't get tripped up on that. For instance, I'll use my alma mater, University of Florida. So we're a Jordan brand school. But let's say, so if an athlete, if a football player wants to wear Adidas on the field, that would almost certainly be a conflict with the existing contract buy-in between UF and Jordan brand. However, that deal unlikely extends beyond so that the athlete has to wear Jordan brand in his dorm room. So there is a situation wherein the athlete would be able to get paid by Adidas, promote Adidas on, let's say, Instagram, showing a picture of him wearing Adidas in his dorm room, and that not being a violation or causing a breach of the existing agreement between UF and Jordan brands. So you want to be really careful. If you're in one of those states that has a law, you need to be very careful in reading it very closely to determine what it actually says.
Darren, we got a couple of questions from the audience. I know we're probably 10, 15 minutes out from the end of our time. I do want to give some folks the opportunity to ask you some Q&A. I love the early steps of disclosure, time requirement, and the ability to approve or deny those transactions. We can maybe circle back and continue to go on some of those. Tarian, I'm going to call on you, man. Let's break the ice. Instead of me reading your question, come off mute, and I want to make sure that I frame it properly. So feel free to jump in and ask away.
Thank you, Kevin. And my apologies, I'm in the airport right now. So.
Oh, no. The first guy I called on is in the air. Would you rather me read the question?
I would, if you wouldn't mind.
All right. Look, I had good intentions. I was trying to break the ice, and I call on Tori, and he's in like security line. So my apologies. Darren, the question is, has there been any additional clarity from the federal government on how to advise international student athletes on NIL and the potential impact on their visa status?
No, and that's an excellent question. And I've seen it brought up time and time again. And I wish there was some clarity there. I think to be super cautious, you would avoid having them enter into any deals at this point in time. I have not received any clarity on that subject thus far, but it's an excellent question. And hopefully the federal government does provide some guidance sometime in the near future.
So short answer, don't put yourself at risk. Wait and see until we have further clarity. Great question, Tori, and thank you. Hope you travel safe as well, and don't lose your bags. Chris Davis if you are not in an airport, please feel free to jump in and ask any question that you may have.
Hey, Darren, question. You mentioned about the use of marks and about having a policy and the whole IP deal. You also said to stay consistent. The question I would have is, what would you even recommend is a policy if you're trying from a university from an IP standpoint, and also the fact that you want to protect, your rights holders, you want to protect the university, and on top of that, making sure that student athlete is, that there's not quote unquote an end around of connection to the brand by using IP. I use the NFL model. Even Peyton Manning, as recognizable as he is, you never saw him in a Colts or a Broncos jersey ever, because the NFL protected that. just curious what your thoughts were on expanding on that.
Yeah, again, this is a pretty common question that I'm fielding within the past days alone. I think it's a safe route to take that there has to be some sort of licensing arrangement in place. And so to the extent that a third party, if you put the I personally prefer putting the onus on the third party as opposed to the athlete. If a third party wants to be able to use the marks of the university in any sort of advertisement that also uses the NIL of the athlete, put the burden on the third party to pay whatever the licensing fee is, either directly to the university or through the subsidiary that you use or the licensing unit that you use in order to do so. The harder question becomes, what if there's not a third party? What if it's the athlete who is creating his own business or her own business or is doing things unilaterally? And that's a tougher question. If there's not some third party brand, what is going to be your policy? Are you going to flat out allow the athletes to use the marks in any and all occasions? Are you going to deny it in any and all occasions? I think it's really important to be consistent. My personal opinion, and it's hard for me to say this as an athlete rights advocate, but I think it's better to be more restrictive with regard to your rights. That's less of like an antitrust issue where Alston was focused on, and more of an intellectual property issue. It's your rights. You have no obligation to allow third parties, even your athletes, to use those marks in a commercial manner. So I think what's more important is consistency. And the hard questions really surround when there's not that third party, because when there's a third party, put the onus on them to pay it out.
Great question. We have another question from, I'm probably going to crush this last name, Matt Lazewski. If you are not at an amusement park and you would like to jump in for a question, feel free.
Kevin, it's I'm actually in my dining room, so we're good.
Great.
So two questions. Where does federal Pell Grants come into play here? Because last year was $6,495 is the federal Pell Grant for students that display serious financial need. At what point do you tell your student athlete, and that's non-taxable income? I would assume that if you're getting paid to do Instagram posts, that's taxable income. At what point do you tell your student athletes possibly to turn down these opportunities because they won't then qualify for a federal Pell Grant? And then second question, we see it in professional sports where free agents are recruited to states that have no state income tax. Do we see that at some point possibly where a Zion Williamson will go to a Florida or a Texas because there's no state income tax?
I'll take the second question first. I think it's possible, although you would think that so many more professional athletes would act in accordance with your suggestion and prefer to play in states where there is zero or low income state income taxes. And there are circumstances, but I will tell you it's rare, which is very interesting. So I do wonder how much of an effect that will have on the player's decision-making process. I think other factors will play a larger role, but certainly that can play a role, absolutely. In terms of the first question with the Pell Grants, my personal, and this is me speaking as a lawyer, my perspective on that is I, as the university, would not want to get involved in the decision-making process there. However, one point that I did not get to mention in terms of what I would suggest as a model policy is and we include this in our state law in Florida, is to require a financial literacy and life skills workshop at the beginning of an athlete's first year and third years of enrollment. This way, you're at least educating the athlete on those types of issues, but ultimately let the athlete make that type of decision for his or her own best benefit, right? I think it's very difficult for you as a university to go in there and try to tell the athlete what is right and what is wrong, because certainly the answer differs on a case-by-case basis. And the last thing that you want is obviously extra exposure. If you tell the athlete to do something, it does not work out to the athlete's advantage, then obviously you're putting the university's exposure at risk. So I would absolutely use and utilize financial literacy, life skills type workshops, require them immediately, make sure that the the type of information that's being provided is something that will be beneficial, such as a discussion about the positives and negatives of receiving income and what effect that can have on the Pell Grants.
Great questions. If there's any others, please feel free to raise a hand or throw that in the chat box. Darren, let's circle back. We got 3 minutes or so left here, but let's circle back on the legislative tent poles, right? We talked about if I'm a school and I need to be creating my own policies and framework. We talked about disclosure and timing of disclosure and things of that nature. What else should schools be thinking about in terms of, kind of major tenets that should be present in that framework?
Yeah, I think we've hit on a lot of subjects. One that we haven't is you definitely need to carve out certain types of companies and industries. You don't want to have the athletes doing endorsement deals or creating businesses in association with things like alcohol, with tobacco products, with companies that are involved with controlled substances, steroids. I'd stay away from casino betting, sports betting, and adult entertainment businesses. I think those are really important areas that, I wouldn't want to go too far, but I think those can all be justified under your existing codes.
Yeah, I'd like to dig into that a little bit more, because if schools in fact have the ability to set the rules, and the Supreme Court has just indicated that less restrictive is much better than more restrictive, what grounds would a school kind of stand on to say we're going to actually restrict you from certain categories of business that the student athlete may otherwise be fine with or okay with, whether it's they're old enough to chew tobacco or they're legally old enough to drink? What position would the school take there?
So a few distinctions need to be made. One, the Supreme Court case only dealt with academic related expenses. It did not have anything to do with athletic related expenses or anything beyond academics, including name, image, and likeness. So that's number one. Number two, the case was really about the NCAA being a cartel and colluding to limit how much can be paid out. So it was strictly an antitrust case. It was based on Section 1 of the Sherman Antitrust Act. So the specifics of the Alston case and the ruling therefrom really play no role with regard to restrictions that individual schools would place. The reason why the NCAA is now so petrified about passing the legislation that it's had on name, image, and likeness for so long is because it still is a quote unquote cartel from the perspective of the Supreme Court. And if it's telling schools collectively that it can't do certain things and athletes that they can't do certain things, they basically end up back in the same position that they were just in. But that doesn't mean that the individual schools can't rest on their existing policies and their codes in order to restrict athletes from participating in certain types of activities.
So I guess while we were actually on this question, I got a question from Jason Coomer saying, hey, I understand staying away from these spaces, but how long until the first lawsuit saying that you can't restrict me as a student athlete? That seems like the natural course of this. And as Jason said, kind of how we got here. But is it the case that existing maybe code of conduct at an institution would provide the school the cover that they need from a legal perspective?
Without digging into each of your respective codes of conduct, if the athlete, essentially it's a contract, the athlete is agreeing to abide by that code of conduct in order to receive the benefits that the athlete is getting from the university. So I think certainly there can be lawsuits. There's lawsuits filed on a daily basis about everything, and many of them are frivolous. And I expect that there will be lawsuits filed, no matter what you do, even if you do nothing. But I do think that you can rest on any sort of agreement that the athlete has with you to abide by the code. And if the code includes staying away from certain industries and activities, then you can rest on that, I think, effectively. I mean, what's the alternative? The alternative is that your athletes are actually participating in these types of businesses and endorsing them. And I think I'd rather defend against a lawsuit than have the alternative, to be honest.
Sure. It's a great point. Should universities think about updating their codes of conduct to provide a little bit more insulation? Is that a step that maybe some schools should take?
Absolutely. Yeah. I think it should be reviewed on an annual basis anyway, if not more. But yeah, given the circumstances that we have in front of us, I know and I understand that you don't have much time, but absolutely, I would.
Excellent. We are at the end of our time. We could probably keep rolling on this for the next several hours, but Darren, I appreciate your time. This has been great, really impactful and really helpful for this audience. So again, thank you everyone for the opportunity to partner on this event and take part in TopConnect. Darren, thank you again for joining us. Doc, thanks again to your crew, and we look forward to seeing everybody soon.